On this 7th part of the Benson Car Bombing saga, we go through the events of the trial, and if you thought all of the crazy, unhinged stories had been aired already, you better strap in, because the insanity around this trial seemingly has no end. We'll carefully lay out the prosecution's case and the defense's rebuttal and have some commentary on the strategic decisions made throughout the trial. This case still has several surprises to reveal, so join us as we dig in on our second to last episode of the Benson family car bombing on Crime to Burn. Welcome to Crime to Burn, where we explore the dark city landscape where true crime intersects with arson and criminal negligence. Join us as we sift through the ashes and bring you the story of what really happened. Welcome to Crime to Burn. I'm April, a fire protection engineer and former firefighter.
And I'm the co-host, the former Dread Pirate Robinson.
But you're not drinking rum.
I said former.
Oh.
I switched to beer now.
Okay.
I've calmed down.
Please subscribe to our YouTube channel, and if you do that, go and like the content that you see there. It's a really, really big help to the pod. The biggest compliment you can give to any podcast you follow is to subscribe to their show on whatever platform you used to listen to it on, and leave a 5-star review. We are very active on Instagram, somewhat active on Facebook, and a little bit active on Twitter, so you can follow us in any of those places. I update there daily, and I share fun stories like how I accidentally created a bomb one time. You'll want to hear that. Before we get into the story, I have to give a quick shout out to a couple friends of the pod. First is another true crime podcast called Like Mother Like Murder. They recently talked about Crime to Burn and specifically about their obsession with the Benson case on one of their recent episodes. So thank you ladies very, very much. And on the episode after that, they attempted a Gregorian chant at my recommendation that made me almost choke on my coffee. It was hilarious.
I don't even know what that is.
They didn't either. I had to send them examples.
Well, it sounds like you're having fun with your friends.
Yeah, I was having fun with my friends. But they're awesome, and they're very compassionate true crime podcasters. So if you guys have not checked them out, please go do that. And the other podcast I specifically wanted to mention is the One Nothing podcast. David and Amanda are friends of the pod, and we follow them on Instagram, and you guys should too. And so you guys should definitely check out Like Mother Like Murder and the One Nothing podcast after you listen to this, and you have to hang on and wait for that very last episode of the Benson case. All right, are you ready for a quick overview? We're going to try to go fast.
Yeah, do it. Speedrun it.
All right, so we know after 6 episodes a car exploded, and it killed Margaret and Scott Benson and severely injured Carolyn Benson Kendall. Police suspect Stephen Benson did it because his mother found out that he was essentially embezzling money from her. However, Carolyn had told investigators that he'd stolen millions of dollars when in reality it was only about $112,000. But investigators think that Margaret had called Wayne Kerr to Florida to help her investigate, and that maybe Kerr tipped off his friend Stephen. Remember, Stephen was best man in Kerr's wedding. And so Stephen was worried that his mother was going to cut him off, so investigators think that the motive is purely financial. As for means, Stephen owns a alarm business and knows electronics well, and some guy in Pennsylvania said that a couple years ago he saw Stephen carrying something that looked something like a bomb and heard a loud noise. That was enough for investigators for means, and he would have opportunity because he did take the Suburban on a suspiciously long coffee run right before the bombing. Now, investigators still don't know how the bomb was triggered, but they're presuming that it was either tied to the electrical system in the car and would have been triggered when Scott started the ignition, or it was remote controlled, but they did not find any remotes during their searches. In their investigation, police learned that Scott was involved in some shady deals and may have been in debt to some drug dealers, but they don't really seem too concerned about that because they think Stephen's motive, means, and opportunity are far too enticing to be distracted by other possibilities. They do find a hardware store that sold some pipe end caps like the ones recovered from the scene, and this store is suspiciously close to Stephen's office, but none of the clerks can identify Stephen from a photo lineup. However, they got a handprint off of the receipts for the pipe end caps as well as off of receipts for some pipe sections that they believe were used in the bombing.
Excuse me, sir, where's the bomb section of the store?
The problem is that they didn't have Stephen's handprints, and Stephen wasn't feeling especially cooperative, so they actually needed a warrant to compel him to give his prints, but this kind of warrant did not yet have any legal precedent, so they needed a super compelling reason to get a judge to sign off on such a warrant, and they did that by taking Carolyn's official statement to police and cutting and pasting it together to be much more compelling than it actually was, and supportive of their position, without including any of the potential mitigating statements, and definitely nothing of her unhinged accusations of Debbie, which may have given a judge pause to question her reliability. Now, once they get that handprint, they're able to match it to Stephen, and he's arrested. And we found out that during all of this, there had been a secret will that no one knew about that excluded Wayne Kerr as executor and trustee, and that Wayne, for some reason, had tried to withdraw $1 million from Mrs. Benson's accounts immediately after the bombing, but was unsuccessful. Now that Stephen is in jail awaiting trial, we came upon the complication that he actually has no money without Mommy to pay him, and so he can't actually afford an attorney. So they appoint a lawyer named Carl Westerman to represent all of the potential claimants to the estate, and they are able to come up with a deal that allows both Stephen and Carolyn to take some disbursement from the estate in order to cover Carolyn's medical bills and Stephen's defense. However, the amount of money Stephen can use for his defense is capped at $105,000, and that is not a lot of money for a murder trial defense. Also, we talked about a guy named Guido Dalmolin who initially agreed to help police by recording a party at a drug dealer's home, but apparently he had a little mix-up with the play and record buttons, and instead of getting dirt on Scott's illicit affairs, he received a beatdown. And finally, we learned that my husband finds it alarming when I say beef, and this has no bearing on the case, but has been a constant source of entertainment for me. All caught up now?
Yeah.
Wait, there's more.
But wait.
There's more. And finally, we learned that the defense team argued that because the search warrant for Stephen's handprint was based on a statement that contained false and misleading information, that the handprint should be thrown out by the judge. But the judge disagreed, and the handprint was admitted. I still find this hard to believe. The statement that Carolyn made in the hospital just sounds so crazy and rambling and outright insane at times. But to read the sworn warrant, it sounds like someone completely different. And I personally think that this alone should have been adequate grounds for an appeal in the event that Stephen is found guilty. But let's dive into the rest of the case and find out what other pearls of potential we can find in this muck, shall we? So in this episode, we're going to be discussing the prosecution's case, the defense's rebuttals and counter assertions, and so basically the overall legal strategy. And I thought that once we got to the case, we would have revealed most of the crazy, but no, we have not. There is so much more crazy to come.
So much more for me to have to block out of my mind.
All right, are you ready?
Later. Yeah.
So now anytime someone is going in front of a jury, jury selection is absolutely a part of the legal strategy. For example, if someone on the jury is married to a cop, they're liable to be more sympathetic to the police. If someone's been tried for a crime, they might be more sympathetic to the defense. So voir dire, or the process of selecting jurors, can become a pretty lengthy process, and it was here as well. Now, the case was moved from Collier County to Lee County, but this is not, I want to make sure everyone understands, this is not a change of venue, because it's in the same circuit. And Collier County and Lee County are right next to each other. So being so close to where the crime was committed and where it had been consistently front page news for a year now, the defense was very concerned that it was going to be impossible to find a completely impartial jury. I think that was a justifiable concern. The judge disagreed and said that by moving to Lee County, which had a more robust population of year-round residents instead of just snowbirds, they would have a deeper jury pool and an easier time finding an impartial jury. Now, some sources I read said that the reason for the move was actually because the courthouse in Lee County was larger and that they expected this trial to be very popular with tons of press and spectators. But the judge did say that when he rejected the motion to have a change of venue, that if it became impossible to seat a jury within a week, he would consider a change of venue. Now, I've waffled back and forth here, but I think that this was definitely an error by the trial court not changing the venue. This was absolutely front page news in Florida. Almost all of the news sources I could find were in the Florida papers, and there was a lot of coverage also in Lancaster, Pennsylvania. And while other papers nationwide did pick up the stories, I did not find nearly as many national news stories as I might have expected, but I found a ton right there around where it happened. I mean, it was just constantly front page news. And I do admit that this was in 1985, so it is possible that a lot of these newspapers don't have their archives available online back that far. But remember that this also occurred before there would have been a 24-hour news cycle. So I think moving the trial would have definitely made it a lot more reasonable to seat a fully impartial jury. I don't think that you could have lived in Lee or Collier counties and not been exposed to the press on this case on almost a daily basis. But I do admit that back then news was more like by appointment. You had to watch the nightly news or read a physical newspaper. There was no channel that had news on 24 hours a day, and the internet wasn't a thing yet. So I've waffled back and forth a little, but I do think that in order to avoid the potential of opening the door for an appeal, they should have changed the venue. Now, when they do voir dire, they bring in a really big pool of potential jurors, and they give them these questionnaires. They ask all kinds of questions about their careers, whether they're connected to the victims. They give them a list of witnesses and ask if they know any of them, whether they've ever been involved in a jury before or any sort of criminal case. And they're using these questions to try to suss out if anyone might have any bias that can impact their judgment in the case. And then the jurors get questioned by the attorneys about their answers, and each attorney has a set number of people that they can strike without cause. So when they think a juror might be biased in the wrong way, they would look for a reason to strike the juror for cause, because that's not going to count as one of their strikes if the juror has to be let go for cause. Cause would be things like the juror knows one of the witnesses, or the juror tells the judge they already think the defendant's guilty. Or in my case, when I was on a death penalty jury pool, I was in a jury pool where one guy showed up wearing a shirt that said, "Stereotypes may not be fair, but they sure are a time saver." That would be cause. Also, making a snide comment about the death penalty in the jury room before the judge or before the attorneys ask you questions will also not just get you, but your entire jury pool released.
Oh.
Yeah. If I ever have to go in front of that judge, I'm in trouble. Just so you know.
Why? What'd you do?
So it was a death penalty case, and we knew that. And we were sitting, so what they did was they brought us in one day, and they gave us these insane questionnaires. I'm talking like 30 pages at least. And we had to fill out things like, did we watch like shows like CSI and Law and Order? And like, have we ever worked closely with police? Have we ever seen gruesome injuries in our line of work or in our personal lives? And like explain the like they asked all kinds of crazy questions. And then that was like a huge jury pool. Like I want to say maybe like 100 people or more. And then they called us in groups of 20, and they had gone through our questionnaires. And this is where the attorneys got to question us and find out if we had preconceived bias or anything that should exclude us from being on the jury. I was unlikely to be selected anyway because of my fire department experience, because I work closely with cops, and that would make me more sympathetic in a lawyer's eyes to the police. Whether that's true or not doesn't matter. It's what they don't have a lot of time to suss out who might have bias.
They saw you coming. They were like, "Oh,
we gotta get rid of that girl.
Bootlicker, get rid of it."
Well, anyway, we were talking in the jury room after they called us in the courtroom. They read the whole list of charges, and then they read you the whole list of people that are involved in the case and witnesses and everything. And so you have to reveal if you know any of them. And then they call you in one by one. In my case, they called us in one by one, and the attorneys questioned us. Well, when we were back in the jury room waiting for our turn to be discussed with, somebody said, "Wow, this isn't traffic court," talking about the gravity of the situation. And I made a joke that traffic court was where they should institute the death penalty. And that did not go over well. And I got all 20 people on my jury pool sent home.
Nicely done.
So don't make jokes if you're ever on a jury. It is not, it's like the airport. You don't, no jokes. No jokes. So, anyway, if I ever have to go before Judge Constance Russell, I'm in trouble. I've remembered her name all these years. And this happened, I think in 2004 or 2005. I'm still embarrassed about it.
It left an impression on you.
It did. Well, she yelled at me in a courtroom in front of a guy that committed murder. Or, I'm sorry, that was accused of committing murder.
Allegedly.
I don't actually know if he was found guilty or not. Anyway. I think it's worth mentioning here, though, that voir dire is considered on the record. And so the trial, it's part of the trial transcripts. And I read those trial transcripts, and I got the distinct impression that the people that were selected generally really wanted to be on this jury. This was really big news. They all said, like, oh yeah, I've heard some press, but I would have to decide based on the merits of the case presented in court. And it just really seemed to me that some of these people, possibly most of these people, gave answers that were exactly what the court wanted to hear in order to not be eliminated for bias. Now, maybe these people could set aside their preconceived notions from the press reports, but even in cases where potential jurors said they had formed opinions, the prosecution then set about what they called rehabilitating those jurors. Basically, they sat there pressuring them to say that they're able to follow directions and that they've been in stressful situations before where they had to do hard things, and basically like bulldogged them in front of all the other jurors in the jury pool into saying, okay, yeah, I could let go of my preconceived notions and make a decision based on what was in court, what was presented in court. Now, I did check, and these, quote, rehabilitated jurors were not on the jury. But the problem is the jurors that were on the jury heard this bulldogging. So it's not like they're going to go up there and admit if they have some preconceived bias when they know the defense is just going to hound them into basically saying, yes, I can do as instructed, or I'm a terrible person. I can't set aside my prejudice. Like,
that's a fun conundrum to be in.
So that bothered me, but I don't know. Having only been part of voir dire once and being the one that got yelled at by a judge, I don't know. I know in my case that each juror was questioned individually, and the defense asked for that in this case, but the judge denied it. So the jurors were all together when each of them were being questioned. So that means jurors that wanted on the jury heard exactly what they needed to say in order to ensure that they weren't eliminated for cause. So that's another strike in my mind. Now, it's not uncommon for attorneys to bring in special consultants that specialize in jury selection. For example, one of the questions on the jury questionnaire asked whether jurors believed in ESP, extrasensory perception.
Did they?
And while this has zero bearing on the case, apparently people who believe in ESP are more likely to oppose the death penalty.
Huh.
And people that...
Do you think that's because they're hippies?
I don't know. But they also said that people that report that they like carefully plan out like every single step of their vacation in great detail are more likely to vote for the death penalty, which I don't know where they get this information, but somebody who is good at statistics, I guess, came up with all this. Anyway, in this case, the defense did hire one of these jury consultants, a woman named Margaret Covington. And she gave them advice like, and this is real advice she gave them, nix the woman that's a belly dancer, because entertainers tend to be people pleasers, and so she's likely to be heavily swayed by the others instead of forming her own opinion.
I don't know. I found that belly dancers are pretty independent thinkers.
I don't know that I know any belly dancers, but I just thought that that was a strange reason. But this woman, Margaret Covington, she was a lawyer, and she had a psychology degree, and she minored in math and statistics. So she's a smart lady. And she also put together something called a shadow jury. Now, once the jury was selected, she went and hired 6 people from similar backgrounds and with similar lifestyles to the 12 jurors, and these people were paid to sit in the audience each day of the trial and pay attention, and every night Miss Covington would call them and talk to them about their impressions and which way they were leaning, because the assumption is that since these people are similar to the jurors, they're likely to reflect the jurors' feelings during testimony.
Do people do that very often? I've never heard that. Sounds clever, but I've never heard of that.
I had never heard of it until this case, but it kind of makes sense, because if the defense can get sort of a feel for what people are thinking, how things go, they can sort of shift their strategy a little bit mid-trial if they need to.
Yeah, it's kind of like a focus group for a product or something.
Yeah. Once the trial started, she went back to Texas, where she's from, and she communicated with the shadow jurors daily to inform the defense how these shadow jurors were feeling after each day's testimony. But even this aspect of the trial is wrought with controversy. It turns out Ms. Covington was dealing with a bit of her own legal trouble. She'd had a son with a former romantic partner, and when he refused to admit paternity, 2 men showed up at his office to rough him up, and oh yeah, they shot him in the chest.
Wait, rough him up? That's really rough.
That's pretty rough. Now, he lived, But one of the two assailants was caught, and he actually testified against Covington that she had paid him to, quote, injure and sexually incapacitate, unquote, the man in question.
Oh.
Now, he testified against Covington, and in December of 1985, so between the bombing and when the trial for Stephen started, she was actually convicted. However, a judge, for some reason that I didn't dig into because it's not really germane to the case, acquitted her after the fact. So she's convicted in December, and this is the next summer that she's now serving as this jury consultant. However, after the trial in 1986, she was indicted again, but this time on 2 counts of using interstate facilities or travel to commit a violent crime to further an alleged extortion scheme for the same incident. Now, all I can guess is that they chose her because maybe her services were steeply discounted because she was in the middle of this controversy and they had a very set budget. But, I mean, your jury consultant was basically charged with hiring a hitman.
Well, so they kind of know how the system works already.
I guess. I mean, she is a lawyer. Anyway, I don't know the outcome of that case. I had to force myself not to dig into it because I have a tendency to chase rabbit holes, and I needed to focus on the Benson case, but you guys are encouraged and welcome to chase that one down.
How fast does a rabbit hole run?
You know what I mean. Back to the shadow jury. It's also really important to know that the shadow jury is given the exact same instructions that the jury is given, and they have to agree to them. So their instructions are, you cannot speak to anyone about the case. You can't follow any news stories. You can't read any news. And bafflingly, in a case that had this much press coverage, the jury was not sequestered. The defense screamed and demanded that the jury be sequestered, and the judge refused. So they're supposed to go home every night where the case is top of the headline news all day, every day, and avoid all discussions about the case, avoid any press, and there were multiple motions during the trial to sequester the jury because the defense, they even said at one point they went to get coffee in the courthouse and there were jurors waiting to get their morning coffee standing right next to a newsstand where this was the front page news on every newspaper facing them while they're just trying to get their coffee in the courthouse. So there's no way they weren't seeing press. And I gotta agree. I think the trial court erred here. I think that jury should have been sequestered.
Makes sense.
But the judge thought that the jurors could be trusted not to be tempted by news stories or their families or friends into discussing the case. And so this is the same instruction that the shadow jury was given. So what did the shadow jury think of the defense strategy to highlight that the police hadn't done their job ruling out Scott's drug debts as a potential motive? Well, it turns out that when they were questioned about Scott's drug use and his connections to people that might have wanted to harm him, the shadow jury basically dismissed these as being not relevant because Scott was such a good tennis player. And other reasons they gave shown that they were absolutely being influenced by the press because in Margaret Covington's conversations with them, they all mentioned things that hadn't been brought up in the trial and were only in the press. So if the shadow jury was being heavily influenced by the press, then it stands to reason that this non-sequestered actual jury was probably under similar influences outside the courtroom. Obviously, a huge part of both the prosecution and defense strategy is to seat a jury that they felt would be more sympathetic to the version of Mr. Benson that they are trying to portray. So the prosecution wants to portray him as a cold-hearted, money-hungry psychopath that tried to murder his entire family in order to get his inheritance, and the defense is trying to paint him as a misunderstood, nerdy guy that was being accused of murder simply because the police hadn't seriously considered any other suspects. Specifically, Scott's supposed drug dealing contacts to whom he owed some very large debts, allegedly.
Allegedly.
So prosecution step 1. Prove Stephen had motive and that he was afraid that his mom found out about his financial dishonesty and that was his motive. However, we know that the amount of money he quote-unquote embezzled was literally somewhere on the order of $100,000 to $12,000, and that number is a little bit in question. But Carol Lynn had asserted that it was $2.5 million, and that's what the press had been saying. So how do you make that amount sound compelling to a jury when they've probably seen in the press for months that the case is over a much larger and more significant number? Well, you defray the damage of that information by boring the jury to death. The prosecution called a forensic financial expert, and she went through every transaction in such scrupulous and boring detail that jurors fell asleep at times, and everyone was reportedly completely glazed-eyed and probably considering their own mortality and how much of their life was being wasted listening to this boring drivel. But by the time the financial testimony was over, the jury was so relieved it was over that it didn't really seem like anyone registered that the financial crimes had been so deeply overstated. So the defense's job here is to emphasize to the jury that the amount of money Benson may have misappropriated was much smaller and couldn't possibly be big enough to be motive for murder. So in cross-examining the forensic accountant, they called many of those transactions into question to get her to admit that it's possible the sum Stephen had supposedly misappropriated was actually even lower than $112,000. In fact, by suggesting that they didn't have any proof that Margaret hadn't approved some of the disbursements, that they could whittle it down to somewhere closer to between $60,000 and $85,000. Now, Kim Beagle testified. She was Scott's girlfriend, remember? And she indicated that Scott had largely quit drugs because of his training, which I do not for 1 second believe. He's never taken his career seriously enough to quit before, but she said that now he's entering the U.S. Open and he's become more dedicated. And Kim, and reportedly everyone else on Earth, believed wholeheartedly that Scott had been admitted to the U.S. Open. And supposedly even Stephen believed this, because the defense never questioned it. They never picked up the phone and called to find out and verify this story, and we didn't find out till after the trial that this was just some delusion on Scott's part. And knowing that Scott hadn't actually been admitted to the U.S. Open may have actually been germane to the case, because Kim asserted Scott had gotten more serious about his training. He had quit drugs, even though he still had a nitrous tank next to his bed, and literally no one else said that Scott was avoiding drugs. So I think this was a huge error the defense made in not picking up the phone and calling and making sure that Scott had really been admitted to the U.S. Open. And I think that's really sloppy defense work, considering that Florida's a death penalty state and this was a death penalty case.
I don't want to be too critical, but sounds like there's a lot of shortcomings in that court system.
Oh, there was a lot of error. I think that the court erred more than the defense erred, but we'll get to that. Now, step 2 for the prosecution is indict Stephen over his actions right after the bombing to paint him as a cold-hearted psychopath. So the defense calls Carol Lynn Benson Kendall to the stand. Now, she is still in bandages, but she's still an attractive woman, and she is a witness that can garner a lot of sympathy. So here the defense has to be exceptionally careful. Shredding a victim and a sympathetic witness is something that angers jurors, and it can actually really hurt the defense. But the crux of Carolyn's testimony in court was that Stephen had called the house on the 8th while Margaret and Wayne Kerr were on their way to see Meridian Marketing and to see Stephen's house. And he called to ask Carolyn specifically where his mother and Kerr were headed, and she had lied to him because Margaret had told her to. Margaret didn't want Stephen to know that she was investigating his financial misdeeds. And then she said that after dinner that night, Stephen called again, and this is when he insisted that they all go together the next day to stake out the house, and this was a surprise and seemed out of character to her. Now, she testified that Stephen masterminded the seating arrangements and specifically had Scott and Margaret in the front seat, but much of this contradicted her earlier statements, some in very material ways and some in relatively minor ways. But the defense had the opportunity here to literally shred her on the stand and absolutely indict her and kill her credibility by pointing out these discrepancies. But doing that could have been at the risk of alienating the jury. So the most compelling part of Carolyn's statement was that she told the court that after the explosion, she looks up and sees Stephen standing there, and then he ran away from her instead of coming to help her. Now, we know this is when he ran into the house and told Kerr to call 911. Now, the defense tried to impeach Carolyn without appearing to badger her, since she's a very sympathetic and likable person. However, in the process of bringing up discrepancies in her testimony and her depositions, Carolyn got exceptionally emotional and heated, and she actually snapped at McDonnell more than once. McDonnell was the defense attorney. Essentially, he was trying to get her to answer a question without any extra elaboration to explain her statements and why they might have been different. And when he tried to stop her from explaining, she snapped at him that she would answer his question, but she wasn't going to allow him to take it out of context by not letting her fully answer it. And this was such a tense moment in the courtroom and so emotional that it was front page news on every newspaper. So by the end of cross-examination, Carolyn was angry. The jury saw a woman that had been severely injured. McDonnell, the defense attorney, had been insistent but gentle with her, and so the shadow jury asserted that Carolyn wasn't adequately impeached at all by the defense questioning. And so Covington, the jury consultant, recommended to McDonnell that he call her again as a defense witness and absolutely shred her. He declined to do this. Now, this isn't necessarily ineffective assistance of counsel. It was a strategy. It was a strategic decision. So this, I don't think, was an error by the defense. I think it was a strategic decision because the jury, there's nothing he was going to be able to do or say that was not going to make Carolyn sympathetic to the jury. The prosecution also paraded a line of people through court that had interacted with Stephen Benson immediately following the bombing. And they talked about his joking around and about his question about getting money in that day. And the defense approached these witnesses with what I think was clever. They tried to get them to admit that testifying at the trial was a stressful situation. And then he asked them a bunch of mundane questions and then would crack a joke. And when the witness laughed, the lawyer would point out that, see, it's not uncommon to joke around or laugh in insanely stressful situations.
Oh, very clever.
So I thought that was clever, but it really didn't seem very convincing to the shadow jury. So step 3 for the prosecution is show the defendant had means. Now, they already had the receipts with the palm prints on them. But when they put the clerks on the stand, they didn't get what they wanted. The clerks would not say that the person that bought the end cap looked like Stephen. And they held out that the person was wearing a hat and sunglasses, that they even said that they didn't think that the composite sketch the police had put together were very reflective of what they had said the person looked like, because they said the face was too wide and the glasses were all wrong. And because they put clear glasses on in the sketch, they used eyes that looked like Stephen Benson's eyes. And the clerk was like, I never said that's what his eyes looked like because I didn't see his eyes.
Oh, that's suspect.
Yeah, so the prosecution tried really hard to say, here's the composite, and it looks just like Stephen Benson, but the clerks really didn't help him there. So this was a win in some part for the defense. However, that was really strongly overshadowed by the fact that the palm print on the receipts was a match to Stephen, and a pretty irrefutable match. It was like a 60-point match, which is really high. So Stephen definitely touched that receipt. Now, the prosecution asserted that Hughes Supply was right down the street from Benson's office, and he could have easily gotten there and back and purchased the pipes on July 5th, the day that the materials were purchased. But Brenda Turnbull was Benson's secretary at Meriden Security, and she testified for the defense that she knew Stephen was in the office at the time the purchases were made, because she said she was a clock watcher. However, she had initially made statements a few days after the bombing that Stephen had not been in the office during those times, and then later she called investigators and said she had had her days mixed up and was confusing July 8th with July 5th. So, understandably, the prosecution absolutely shredded her credibility on the witness stand, and she actually started crying at one point, and so this really was not a good look for the defense. So, the prosecution did the level of shredding to Brenda Turnbull that the defense declined to do to Carolyn, and I think that really hurt the prosecution, or the defense's case. Also, the prosecution made sure to point out that Brenda Turnbull was the only Meridian Securities employee that got paid after the bombing. Everyone else, because the company went belly up, Stephen didn't have any money, they didn't get paid. And several of them actually threatened to do and say things that would hurt Stephen in the trial if they didn't get paid, but Brenda Turnbull was the only one that got paid. And now she's trying to testify for the defense that, oh, I made a mistake. This is what really happened. It fell pretty flat in court.
Yeah, I imagine it would.
Now, the defense had lost their motion to toss the palm print due to the fact that the warrant was based on false and misleading statements. And so they had to address the seemingly smoking gun of the palm print in court. Now, obviously, the prosecution's going to lean really heavily on this. It is the only piece of physical evidence they have that ties Stephen to the case. And even the link between these end caps and the actual ones used in the bombing are circumstantial. So the defense focused really heavily on trying to indict the palm print and saying that because they didn't use the FBI's recommended process for collecting the print, that it wasn't accurate. But from what I learned in my research, that's really not the case, and it wasn't a successful argument, and it fell very flat in court. Now, what the defense did not do was hire an independent print examiner to look at the palm print. Now, this may have been because by this point, Stephen's measly $105,000 defense budget had pretty much been spent. In fact, they went way over budget on his defense. But it just seems to me that if that's the only piece of evidence that ties Stephen to the purchase of those items, that should have been, in my mind, the first thing they tried to indict, is to find another print expert to potentially refute that testimony. They didn't do that. And I think the reason why they didn't was because Brenda Turnbull originally told police that Stephen was out of the office during the time the materials were purchased and then changed her story. And plus, this didn't make it into court, but I did find at one point she had actually told police that the day that these things had been purchased, Stephen had been asking around the office if anyone had a baseball cap he could borrow. And we know that the person that made the purchase at Hughes Supply was wearing a baseball cap. I don't know why that didn't make it into court, but it did. So all this is not looking good for the defense. But let's remember one thing here. Even if Stephen did buy the pipes and the end caps, they don't have proof that these are the exact pipes or end caps used in the bombs. In fact, there was one witness that testified as an expert that the oxidation investigators found on the pipes used in the bombings showed that these particular pipes and end caps could not have been the ones used because the level of oxidation was different and showed that these were older pipes. However, this really didn't sway the jury. And what I don't know and what I couldn't find out is if the heat and fire from the bomb may have affected that oxidation, but it was pretty weak and it really didn't sway the jury very much. Oh, and in the middle of the trial, movie producers showed up to court because they were considering optioning the story for a movie. So the producer that made the Amityville Horror was in court.
Really?
Yeah, he showed up in a limo and all dressed up in his finery. People commented that he was wearing Gucci and gold and...
Is that like Hollywood's version of an ambulance chaser?
I don't know. Maybe. Anyway, he apparently came for one morning session, stayed until lunch, left in his limo, and never returned. But did reportedly option the movie, but it never got made.
He probably thought it was just too weird.
Everything about this case was weird. Step 4. The prosecution has to show that Stephen had opportunity. Now, they harped on the fact that Stephen had been gone so long to get coffee. But note that every witness had a different accounting of how long he'd been gone, anywhere from 30 minutes to well over an hour. So the defense here really just tried to pick apart timelines and focus on the fact that the truth is we don't really know how long he was gone, and I don't think this was convincing to anyone, especially since Stephen had been gone so long talking to reportedly someone he knew, but he could never remember their name at the convenience store. So the prosecution actually went to the construction company that he said he ran into somebody from to find out who might have been in the area at the time, and the construction company had no one that could have been in that area at that time. It made it appear that Stephen had lied about why he was gone so long. Now, once the prosecution rested, giving the jury a pretty reasonable case that Stephen had means, motive, and opportunity, it's now up to the defense to paint a completely different picture of Stephen and the events of that day. So the first thing his attorney, Michael McDonald, does is fill the row of seats immediately behind the defendant, because this is usually the seats that are reserved for the defendant's family. Only no one showed up to support Stephen. His wife never showed up. Harry Hitchcock and Margaret's sister, Janet Lee, did show up, but they sat behind the prosecution. So MacDonald didn't want to leave this row of seats empty, so he put his own family there, and he put his own mother-in-law there, actually, in that seat. And so the press began referring to her as a rent-a-mom.
Oh. What movie was that where you could rent a mourner?
Oh, I don't know. I have no idea what you're talking about. There's a movie where you could rent a mourner?
Yeah, maybe it was like a Mel Brooks thing or something. But, yeah.
We'll have to try to
People
find
would
out.
wail and pretend to be upset at your funeral.
I've seen memes where people say that for a fee they'll show up at your funeral and stand like off in the distance wearing all black and holding an umbrella and looking like suspicious so everyone thinks you had some sort of secret when you died.
For extra $100, they'll jump on the casket and be like, no.
Yeah. Anyway, so knowing that they had not done an adequate job of impeaching the prosecution's star witness or poking enough holes in anyone's testimony to introduce reasonable doubt, MacDonald decided to focus on the only thing he could focus on, the other people that might have killed the Bensons, and the police zeroed in on Stephen too fast, and so they just didn't look for exculpatory evidence. So first they interviewed people that lived near Margaret Benson that had complained to the sheriff's office on multiple times that shrapnel from the bomb was still embedded in their house, in their screen doors, in their yard, and asking them to please come collect it so they could finish making repairs and do their lawn work without taking shrapnel. But the sheriff's office never came to collect any of that. So the defense tried to say that police had done a shoddy job of collecting evidence, and by doing that they may have missed evidence that could have been exculpatory. Now, given that the bomb evidence only gave us the relative size and shape of the bomb and didn't offer any fingerprints or DNA evidence, DNA evidence wouldn't have even been a thing yet in 85, I don't know that this really changes anything. But it does make the police look a little more like the Keystone Cops, and we're about to see them look a lot more like the Keystone Cops, so hold on. But they really don't have anything directly tying Stephen to the bomb, so the defense harped on the fact that since they didn't collect all the evidence, maybe there could have been evidence that tied somebody else to the bomb. Now, one thing I found interesting is that neither book that I read goes into much detail about what police searches may have turned up when they finally got warrants to search the Bensons' houses and offices, or what, if anything, they may have found. But we know that Stephen's smart, so maybe he did make the bombs, and he's really good at cleaning up after himself. I find this fascinating, because I like to make crafts, and when I'm done, it looks like a Michael's store threw up in the house. I can't even make a bowl of Cheerios without leaving a trail of evidence behind me, so...
You're telling the truth, though.
I have a hard time believing that you can make an entire bomb in your house. And these were big bombs. They were estimated to weigh something like 26 pounds each, and not leave something that police would have found in a search. But none of this was introduced in court as evidence.
Huh. Well, okay. So does the bomb have to be made at his house?
Well, that's the thing, is I don't know. Like, I would have liked to know what their story was. If they think he wasn't made at his house, where did he make it?
They just didn't mention any of it.
Or did somebody else make it for him? We don't know. Anyway.
Dun, dun, dun.
Dun, dun, dun. And then the defense put up Guyon Deloach. Remember, he was the lawyer that had made the new will for Margaret. The simple $75 3-page deal. Now, they put him on the stand with the intention of confusing the financial motive, as Stephen didn't know about the new will. However, the prosecution was able to stick a pin in that pretty easily by asking Deloach who the beneficiaries were of the new will, and the answer was, of course, Stephen, Scott, and Carol Lynn. And then he went on to ask if Margaret, Scott, and Carol Lynn were all killed, who would inherit, and Deloach said it would all go to Stephen. However, this is incorrect, according to Florida law. In this case, if Margaret, Scott, and Carol Lynn had all died, Carol Lynn's portion would have gone to her 2 sons, and there was a pending paternity suit with Tracy Mullins, and so Scott's portion could have gone to Tracy Mullins. So it stands to reason that even if Stephen had committed the crime for the inheritance, that he didn't have as much motive as the prosecution was trying to suggest. And so he wouldn't have had any motive to try to kill Scott and Carol Lynn, because killing the 2 of them didn't increase his shares of the will. However, apparently no one understood the law, because no one corrected the misstatement in court, and the jury deliberated and decided, still thinking it was true that Stephen was going to inherit 100% of the estate, and that the bomb successfully killed both of his siblings and his mother. But then one could also argue that if the lawyers didn't even know this, Stephen wouldn't have known it, and even if he was operating under the assumption that the previous will was valid and the new will doesn't change the fact that no matter what way you cut it, he still do inherit a good portion of Margaret's estate. So I'm not sure this really would have had a material impact on how the jury decided, even if it had been cleared up. However, Mushaw, in his book, felt that this was a really major failure in the case. And while I admit it should have been cleared up, I don't think it really changes anything as far as motive. So backed against a wall, the defense's only hope is to convince the jury that somebody else did it. So the defense is now looking for anyone and everyone that can testify about Scott's illegal activities and that he may have been dealing drugs and that he owed the wrong people money. They were able to locate several of Scott's quote-unquote friends, but all the people that they were able to locate were either on probation, in jail, or on parole, and so every single one of them tried to plead the fifth on the stand, saying that it was their right not to incriminate themselves. And this is their right, but it frustrated the defense to no end. They did get one guy up there to tell everyone that at one point Scott had been alone at Kim Beagle's brother's houses, and he saw somebody go into the house and do a large drug deal and come out with a large amount of money, and that would imply that Scott was also dealing drugs because the Beagle brothers weren't home. And he also said that he had heard Scott offer up his Lotus as collateral on $40,000 worth of cocaine. However, the prosecution had no trouble shredding this witness by asking them about how drugs and doing drugs had affected their working memory. And then also by asking them how many times they'd done drugs and wanted to go home and blow up their whole family. So this really fell flat with the jury. But there's a fun twist here. One of the witnesses that had a drug-tangled friendship with Scott was a man named Stephen Fife, and his dad was a witness for the prosecution because he was one of the police detectives that originally investigated the case. And we're going to talk more about Daddy here in just a moment, so remember his name. Thomas Fife is the father. But first we have to get back to another old friend. Remember Guido Dalmolin, the guy that built a replica of a nuclear bomb and had problems figuring out the play button and record buttons on his tape recorder?
It's not exactly forgettable.
Yeah, well, this is where he re-enters the chat. Now recall, he had originally offered to help police by bugging a party and asking about Scott's drug dealing connections and who may have wanted to hurt him. But he never delivered on that because he had some trouble with his tape recorder. Well, at this time, Guido was actually in jail. Now the defense was eager to talk to him to find out if anything he might say could help strengthen the theory that some other guy did it. However, Guido Dalmolin was a genius, and he actually told police when they arrested him and put him in jail that he could escape. And then he proved it by escaping. He picked the lock on his cell, made it to the security control room, managed to lock all of the cops, all of the wardens and everything out of the control room, and started punching buttons until he was able to open the doors he needed to get out.
That's what you call integrity.
So with the disappearance of Dalmolin, the defense is going wild, saying they absolutely have to find him. He's key to their defense, and if they can't find him, it'll have to be a mistrial or at least grounds for an appeal. But lucky for the defense, Detective Thomas Fife, Stephen Fife's father, is driving around one day while the trial's going on, and someone crosses the street in front of his car. He's off duty, but he immediately recognizes that face. It's Guido Dalmolin. And he manages to take Guido back into custody thanks to a random construction worker that joined in the fray and also recognized Dalmolin from the news and joined him in his pursuit. But Fife did suffer some injuries, including a broken toe, and he had to be treated for several human bite wounds after the fray. But he got Dalmolin back into custody.
Who bit him?
Dalmolin.
He's a biter.
He's a biter. Now, when police asked Dalmolin where he'd been spending his time since he escaped, he told them he'd spent some of it on the roof of a Kmart and some of it in the woods, but most of it in the bushes outside investigator Harold Young's house, because Harold Young was one of the officers that questioned Stephen the day of the bombing.
Wow.
Yeah. This guy, I mean, he's nothing if not amusing. I think he might be my favorite player in this whole case. But even after he was rearrested, the defense never called him. And why? They never tell us. But when Michael Mushaw asked McDonnell about this, he said, well, you never put a witness on the stand unless you know exactly what they're going to say, implying that Dalmolin was too much of a loose cannon to put on the stand. But I find this completely baffling. They put a bunch of other guys that were in prison, on parole, and on probation on the stand, not knowing what they were going to say. And Dalmolin had already told police early in the investigation that he could connect Scott with these people in the drug trade, and implied that he was willing to help, or at least had been at one point. And so the fact that the defense's entire strategy hinges on proving that the police didn't do their adequate due diligence in chasing down other possibilities, why would they drop Dalmolin so easily? I don't understand. I have to wonder if there's more to the story.
Oh, bizarre.
We know Dalmolin knew both Scott and Stephen. And so it made me question whether or not there's a connection. And maybe Stephen told his attorney to leave Dalmolin out of it, or if Dalmolin really was too much of a loose cannon, or if they were just all afraid he'd escape if they tried to bring him into the courthouse, or that he'd just find a way to blow them all up. I don't know. I can only speculate. But I think the fact that they never brought Dalmolin in just tickles my brain. It makes me feel like there's more to the story here that we don't know. And then the defense went with Scott's psychiatrist from when he had been Baker acted a few years earlier. Remember, he had had a violent altercation with his mother, and they had put Scott into a mental hospital for several days. So his doctor, Dr. Lombilo, I think is how it's pronounced.
They probably just call him Dr. L.
Yeah. He had been Scott's psychiatrist, and the defense called him to testify, but this was actually really, really risky. Why? Well, recall that the bombing took place in 1985 in July. Well, in September of 1985, Dr. L was sitting in a courtroom himself. What was he doing? He was defending himself on charges of sexual battery of 2 women. Upon executing a search warrant after the women reported the crime, the police found photographs of him simulating sexual acts that he was accused of with the 2 women while they were unconscious. Yet somehow he was found not guilty.
Oh, the 80s.
So there was a chance that Dr. L wasn't going to be a cooperative witness for the defense because the firm McDonnell and Barry, the firm that's representing Stephen, had represented the 2 women in the civil suit against the doctor after he was found not guilty. So he probably had a little bit of a bone to pick with Stephen's attorneys.
Oh, man.
This is so twisted. However, they did bring him in to testify about Scott, and he did represent that the damage done to Scott's brain by all of his drug abuse could cause a form of psychosis and cause him to be violent and suicidal. However, upon cross-examination, the prosecution managed to get him to agree that this would have likely only happened while Scott was actually under the influence of drugs, and within days would have dissipated. And since Kim had already testified that Scott hadn't done drugs the day before the bombing, and because he had to get up early to train, it wasn't convincing to the jury that this was a murder-suicide perpetrated by Scott. But not to worry. The court got to hear exactly how violent Scott could be because, remember Carl Westerman? He was the attorney appointed by the court to represent the estate and the best interests of each claimant to the inheritance. Well, in the documents that he had obtained, he found a smashed cassette tape that he had managed to put back together and listen to, and on it was the actual recording of Scott's verbal assault on Margaret that we've talked about so much. And so he turned it over to the defense.
I wonder why he recorded that.
Margaret recorded it.
Oh.
And so on the recording, which was played in court, you can hear Scott Benson screaming at his mother that he's going to kill her, he's going to have his dog kill her. And apparently when this recording played in court, it was very emotional for everyone, but even Stephen Benson cried in court when it was played. Then a former maid of Mrs. Benson testified that she'd seen Scott physically attack Margaret and Carolyn, and that he would just go mad and couldn't be controlled, and he would have exceptionally violent outbursts. However, even if Scott was violent and probably deluded and possibly psychotic, the jury just didn't get that picture because they are still operating under the assumption that he cleaned himself up and was accepted to the U.S. Open, which we know is false, and so they sort of seemed to dismiss all of this completely out of hand. But even if he was deluded and psychotic, would he be suicidal enough to want to take himself and his entire family out in a car bombing?
I could not speak to that.
But I think it seems pretty weak. Plus, when Kim testified, she testified that the previous day, the day before the bombing, she had been with Scott all afternoon and evening, and they had been in the Suburban, and she had been taking things like her purse and apparently pot in and out of the center console. And so she would have seen if there was a bomb in the console while they were out. So the only time frame that the bomb could have been planted would have been after they returned home late at night and before Stephen got into the car that morning to go on his coffee run, if somebody other than Stephen planted the bomb.
Who's smoking the devil's lettuce?
Scott, reportedly, even though Kim also testified that he was off drugs. So I guess, I don't know, maybe she's saying it was hers.
Huh.
They found it in his room, so he still had pot, so I don't think it's very believable that he was off drugs. But the assertion that the bombs were planted by some sort of drug dealer that had a vendetta is honestly more plausible to me than Scott committing a murder-suicide. However, they had very little in terms of reliable witnesses to back up that this was even a possibility, or as much of a possibility as would be required to induce reasonable doubt. And by not calling Guido Dalmolin, I feel like they really didn't do their full due diligence in defending Stephen. So the defense ultimately rested without Stephen Benson taking the stand in his defense. And that is his right, and it is not an indictment of him. However, juries tend to want defendants to take the stand, and they often ask, if they're innocent, why didn't they testify? But this was a decision made by the defense, and it was a strategic decision. You see, the defense appeared to believe at this point that they had more than enough for an appeal. Between the warrant that used misleading statements and the fact that the jury wasn't sequestered, among other things. However, in order for an appeal to be granted, it has to show not just that the court erred, but that it likely would have had an impact on the jury's decision. And if Stephen testified and he fell apart under the prosecution's cross-examination, he could have reduced that chance that these errors could have swayed the decision. So the defense decided strategically not to have him testify, assuming that they're going to be granted an appeal. And I honestly don't feel that the defense was wrong for this decision, given that everybody was already so incredibly critical of Stephen's personality and his joking on the day of the bombing. I just get the impression that it might have been an uphill battle for him to remain a sympathetic character, or even to become a sympathetic character to the jury. To review, they didn't call Dalmolin. Why? They didn't correct the assertion that Scott was good enough to be a pro tennis player. They didn't correct the misconceptions about how the distribution of the will would have gone to the kids instead of 100% to Stephen. They did not ever talk about Tracy Mullins in court, who had supposedly made death threats against the Bensons for years. And there's one other person that thinks the prosecution absolutely withheld potentially exculpatory evidence and even witnessed a recantation of one of the prosecution's star witnesses, and he was so concerned about it that late in the trial there was a conference between the attorneys and the judge to discuss what had been omitted and whether it required a mistrial. Who was this person? Well, he was also an attorney. He was Carl Westerman, the attorney that represented all the claimants to the estate and the one that had turned over the tape of Scott threatening Margaret to the defense. He had received lots of financial documents to review and had uncovered one piece of evidence never introduced to the jury, and he wanted to make sure that the defense knew of its existence, and he seemed to think that the prosecution was withholding it, and he believed it could be exculpatory. But more shocking, he had been present when the prosecution's star witness completely recanted their statements and insisted that the prosecutor be called and notified that they were going to refuse to testify and wanted to recant their entire statement. And so the prosecution, obviously panicking, rushes in and, quote, rehabilitates the witness. So who recanted and was then rehabilitated into being the prosecution's star witness? We'll find out next week in the finale of the Benson Car Bombing case.
Rehabilitated with a meat mallet.
Well, I will tell you what he told the court happened, and I will leave it up to you to decide if what the prosecution said and did was reasonable or not.
Deal.
Deal. And so that's part 7. We're almost, We're almost about to knock our microphone over. We're almost done. One more part. Desi from the Dead podcast messaged me after listening to our last episode and said she loved hearing Winston in the background, so at least he has one fan. I want your full attention.
I'm at half attention.
This feels weird because I can't look at you and my computer.
When could you ever look at me and your computer simultaneously?
I'm very talented.
Like that,
like a grasshopper. My eyes go in different directions.
like that crab from Moana.
But it feels better. I'm going to punch the microphone. It's just going to happen.
It's your show, man. You can punch it.
Let me put my phone in airplane mode so my adoring fans don't interrupt.
Both of them?
Oh.
Oh.
Oh. He is on fire tonight, kids.
That's a very popular poultry place, and I may have pickled my pancreas. You might have ended up like me.
We might have both been in a coma.
No.
And then who would let the dog out?
Right.
Who would let the dog out?
Who? Who?
He actually has no money without mommy to pay him. And what is the cat doing?
I don't know. It sounds like she's trying to tunnel out of here.
Pause while we return the dog to the interior of the domicile. Come on in, baby. Your fans await the calamity you bring to the pod.
Hey. We should party. Go find that guy.
Be careful what you ask for.
Did you invite him? Is he here?
No, he's not here. But I have located him.
Ooh, you're weird. Why would you do that?
I didn't intentionally do it. LinkedIn actually suggested him to me.
What?
He's on LinkedIn. And I thought, there is no way this is the same guy, right? And then I went and got his mugshot, and he has very distinctive facial features. It's him. It is absolutely him. Okay, so yeah, he said he was spending his time in Harold Young's bushes.
Of course he was.
Okay. All right. They don't fit anybody. It's like somebody who's heard of hands designed them, but has never actually seen hands. Obviously, they were all fine because they were still alive when I left. Well, not that one guy, but that was not because of hydrogen sulfide. I mean, I think he was alive. I don't know if he lived or not. He backed into a ditch witch.
Like, what?
Yeah, he was walking backwards, like backing up from something, and there's a ditch witch going, and took off his leg, most of it, at least.
Oh, man.
And so I'm 19, right, when I'm doing this internship, and we're in BF middle of nowhere. All the fire department rescue squads are home response. It's going to be 20, 30 minutes before an ambulance gets there. This is my first business trip ever. My first time at this plant. I'm there for maybe 30 minutes, and a pickup truck comes screaming up to me and says, "You're an EMT, right?" And I'm like, "Yeah." They're like, "Get in!" Oh. They take me to this guy that has nearly amputated his leg. I got to practice tying tourniquets. I honestly don't know if he lived or not. He was obviously losing massive quantities of blood, and they had a helicopter started. Once the ambulance got there, I got to leave and go back to the hotel and take a shower because it was now
messed up, messy.
This is my first business trip. First of all, I got there the night before, check into my hotel, drop my bags off in my room, leave and go to get lunch or to go get dinner. And I just got something from a drive-thru. I get back to the hotel. Everyone's outside. There's smoke coming out of the hotel. There's fire trucks everywhere. The hotel's on fire.
What?
I sat in the parking lot for 3 hours waiting for them to clear the hotel. The wing that I was staying in was not affected, so I didn't have to change hotels. So that's my first night. Then the next morning, I get to the gas plant. I'm there for 30 minutes, and this happens. This guy backs into the ditch witch. And then I had to go back to the hotel that had been on fire the night before to change my clothes because I was covered in blood. And the people at the front desk gave me looks when I walked in, and I'm like, I'm going to get out of the shower, and there's going to be police knocking on my door because these people will probably think I just murdered somebody. But they didn't, so, you know. Yay to the people at the Holiday Inn for minding their own business. You take your judgmental look somewhere else. Like, the roof of my mouth feels like torn up from all the salt. And I had a salad, which is not impressive.
It's a salty salad.
It had bacon and fried onions in it.
Do we even do a PSA yet?
No, we still haven't done a PSA. What are we going to PSA about?
Just have the AI write it.
You've got the sinuses for it. I typed in safety tips for building a pipe bomb, and it just says, I'm sorry, I cannot assist with that request. In today's fast-paced world, danger can lurk where you least expect it. Cut to a close-up of a suspicious package left unattended.
I got a suspicious package. Should spray that chair down with Pam before you sit in it.
I'm not going to sit in Pam.
You want to go play Crisco Twister?